Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Joined with my co-host, Jesse Barrientes. Jesse, welcome to the show.
Thanks, Dave.
Today we're going to be talking about bankruptcy law, whether it be Chapter 7 or Chapter 13, and we're going to get into some of the specifics. But Jesse, bankruptcy is something that you've been handling in the Chicagoland area for the last decade or so, maybe even longer.
We used to type up the forms on the typewriter. That's how
right.
far that goes back.
So you've seen the changes. Everything from the filing fee increasing, to the amount of people filing increasing, to the reasons why people file. So let's dive in. What is bankruptcy and what's the purpose?
Well, I mean, there are a couple different chapters, Chapter 7 and Chapter 13. Chapter 7 is a complete and total discharge. It's like a fresh start. Chapter 13 is a consolidation or partial repayment where you pay your secured creditors 100% of what you owe and your unsecured as little as 10 cents on the dollar, but it could go all the way up from 10 cents to 100% depending upon your situation and what's available. But people file bankruptcies for a lot of different reasons. Let's just talk about some of the obvious ones. Calamity. Someone is struck down with an illness, and so they can't work, and they have a whole bunch of bills mounting, even with insurance. And so that's a big reason why you can get behind. Sometimes people aren't just, they're not responsible with their credit cards, and a lot of people like that, and it just continues to build up, and people try to rob Peter to pay Paul, and they try to pay their minimum payments. And Dave, you do a lot of bankruptcy too. What happens when you make the minimum payment on your card? Let's just take, for example, a $2,000 balance on your card, and you make the minimum payments. How long is that gonna? What's it gonna do to you?
Oh, I can't calculate it in my head, but it's going to take you a long time to pay off that debt. You're going to pay a lot in interest. By the time you finally pay off the debt, you're probably going to pay close to double, I would estimate, depending on what your interest rate is, as to what your outstanding balance was. So it's going to take many years of making the minimum payments. So really, if you're someone who's just making minimums, you might think you have it good and you're managing everything. You're not doing very well.
Right, and multiply that times 3 or 4 or 5 cards, as a lot of people do.
Or 10.
Or 10, right.
Yeah, and then put on top of that medical bills, personal loans, payday loans, title loans now, which are coming up like crazy, and then real estate foreclosure. People in houses they can't afford, where the interest rate went up beyond what they can pay, the taxes went up beyond what they can pay, and then of course you've got your necessities, food, gas, clothing. Everything is going up except wages.
Right, except your pay, and some other reasons too. That hit people pretty hard are loss of a job. Again, the economy. Also, we were talking in one of our other shows in terms of a divorce. Something happens, and now the bottom falls out of that, and now you're down to a single income. So there's a whole bunch of different reasons that situations that hit people for them to kind of do that. Let me ask you, Dave. Though there's people wonder, should I file a bankruptcy? I know it depends on the situation.
Yeah, I get that question a lot, and it really does depend on the situation. But I have a rule of thumb that I like to tell my clients, and that is if you feel that you can bail yourself out and pay off the debt within a 6-month period, then don't file bankruptcy. Dig down, budget, get the debt paid. If, however, on the other hand, at the end of 6 months, if you're just going to be in the same position, making the minimums, not getting anywhere, just treading water, and it's an endless cycle, then I would strongly consider bankruptcy, because you're showing that you're in need of a fresh start. And there's no reason to struggle indefinitely. I mean, that's why bankruptcy law was put in. It's in the Constitution. Congress passed it. Congress keeps amending the law. It's to give honest people who have done no harm, no fraud, an opportunity to either get a fresh start, get back on their feet, be able to contribute to society again, or to reorganize under Chapter 13. So really, if you're struggling month after month and it's going to be an endless circle each month, then you might want to think about a fresh start.
Well, it even takes a psychophysiological toll on someone, does it not? I mean, there are, emotionally and even physically too. I've seen people that were just emotionally taxed and experienced physical symptoms, just like any stress. Any stress at all will do that.
You're right, and it really breaks down a family and a marriage sometimes when there's financial problems that leads oftentimes to divorce. You'll hear couples say that we fought over money. There wasn't enough money coming in. We didn't allocate it right. I wanted to spend it one way. He wanted to spend another way. So marital problems can be a result, very oftentimes, from financial difficulties. And then just the stress level. If you don't come home happy, if you've been at work all day and you're getting bill collector calls at your job and you're worried about a garnishment and you're worried about a pending lawsuit, it takes a lot out of you. It takes the joy out of life, and that could affect your home life very easily. So we do see a lot of that.
Well, let's just go off on just a little bit of a tangent here, because you mentioned about bill collectors, and we have the Fair Debt Collection Act to protect the consumers, correct?
Yeah, a lot of consumers would say it's not fair at all.
It's not fair at all, but and there are a lot of violations, correct? What happens if, can I tell a creditor that I don't want to be bothered at work?
Yes, you can. You can tell a creditor that you don't want to be bothered at work, and they're prohibited from contacting you there. They're also restricted on when they can call you. They can't call you too early in the morning. They can't call you too late at night. They also can't send you letters if you advise them that you have an attorney, or you send them a letter advising them that you don't want any communication.
So if I don't have an attorney and I just send them a letter that says, hey, listen, you know what? Don't bother me anymore. Can they still call me?
They cannot call you. They cannot send you letters, but they can institute legal action and commence a lawsuit against you. That they can do.
But they can call you or send your letter to tell you that they're not going to call you or send your letter, right?
They can't call you at all. But unfortunately, there's a lot of rogue collection agencies.
Right.
There's some online payday loan places that are not even operating within the United States who are violating the law. They will call up my clients and harass them. They won't give their information. There's no way for me to bring an action against them for violating the law. It's just more and more of this stuff is moving out of the country, this internet money situation, and a lot of my clients are falling victim to it.
Okay. All right, back to bankruptcy here. What's I don't know, it depends upon the specific situation, but okay, I'm $4,000 in debt and I'm making those minimum payments here, and I can't, pull myself up by the bootstraps here in 6 months to kind of make that happen. Is there like a threshold? I mean, is it that I also have some some past due utility bills kind of moved around a little bit, and maybe judgment from an eviction or something like that? I mean, is there a threshold in terms of a dollar amount of unsecured credit that?
There is no dollar amount, but just like a doctor only sees people who are complaining of some sort of illness or injury or pain, the only people that really call me or come in to see me are those that are struggling financially. So it's just a question, not so much of do they need the help, but which chapter is best, and can they get over that hump of actually committing to a filing. There's a lot of misconceptions out there. People are afraid that bankruptcy is going to ruin their life. They'll never get a car again. They'll never get an apartment. They'll never get a mortgage. They'll, God forbid, never get another credit card.
And that's not true, because right after the filing, they're going to get flooded with offers for credit cards. And what's the only difference? The difference is what? The amount of credit they're going to be extended and the interest rate. That's it.
That's true. And some breaking news, too. There's new legislation that just passed called Back to Work, which states that after a bankruptcy case, if you can show that you had to file bankruptcy due to a loss in income, you can qualify for an FHA mortgage after 1 year. So this 10-year on your credit report, I'm never going to have a life again, it's not the case. You can get an auto loan immediately after filing, a secured credit card immediately after filing, and now, under certain circumstances, qualify for a mortgage under FHA after 1 year.
Yeah, a lot of people don't really know that. They just think, hey, they filed a bankruptcy and they're good, they're done. But doesn't it make you a good credit risk, because you can't file another Chapter 7 bankruptcy for another 8 years and a day?
That's correct. So lenders know if they give you a second chance, they're most likely going to be a good risk. You're either going to pay your bill on time and they'll get the interest that way, or they'll be able to collect late fees and higher interest from you, knowing that you cannot discharge the debt in a Chapter 7. You can still wrap it into a Chapter 13 and restructure the payment, but you can't file another Chapter 7 fresh start for 8 years after you filed your previous case.
Well, let's talk about because you mentioned that Chapter 13 we mentioned a little earlier in terms of it being a consolidation or partial repayment in terms of doing that kind of a thing. So, enlighten us a little bit more.
Well, Chapter 13 is the ultimate home saver case, and what I mean by that is people who are struggling and in foreclosure. They have fallen behind on the mortgage. The mortgage company wants one lump sum payment to get caught up. But obviously people can't do that. They were out for an illness, injury, divorce, something like that. They're back working now. They can make the regular payment, and they can put something towards the arrearage and repay it over 3 to 5 years.
But they won't take it. The lender won't take it.
They won't take it. So filing Chapter 13, federal law dictates the lender must start accepting the regular payment, and they must accept the arrearage over a 3 to 5 year period. So when I say a home saver case, it stops the foreclosure dead in its tracks as long as you file your Chapter 13 prior to a sheriff's sale. That's the linchpin. If you're after the sheriff's sale, it's too late. You have to file before it goes to a sheriff's sale because that's the day you actually lose ownership in the property according to the Illinois courts.
And then that's all she wrote for that.
That's all she wrote for Chapter 13, but there's always Chapter 7 and wipe out any deficiency. I want to stress, Jesse, people afraid of Chapter 7, I have personally seen over the last 22 years how Chapter 7 has helped people tremendously. Yes, the thought is not something they want to do. Going to the dentist is not something people want to do. Doing their taxes and paying their taxes is not something they want to do, but some things you got to do. And if you're struggling financially, your life will improve. I've never had a client call me up in 22 years and say, damn, you should have told me not to file. You ruined me. No. I get the other. I get the letters saying I should have done it sooner. My life is better. I got one the other day. I couldn't believe this. The woman told me, and I'm not a doctor, she said, my blood pressure is down thanks to you filing a bankruptcy.
That's the psychophysiological effects that this pressure has on you. But what I wanted to kind of let the folks know too, because we talked about Chapter 7, right? You can't do that fresh start for 8 years and a day. However, you can do a Chapter 13, and that's a partial repayment or consolidation, so you have to have some money left after your allowable expenses to be able to fund the plan to pay your secured creditors 100% through 36 or 60 months, and your unsecured as low as 10 cents on the dollar through that time. But if you file a Chapter 13 after you filed a Chapter 7 within 4 years, what happens?
Well, you're technically not entitled to a discharge, which means you can't pay less than 100% and get a discharge. You could, however, pay less than 100%, but then the remaining portion that was not paid is due and owing. There's a lot of nuances. It's a little tricky, but keep in mind, even for a debt that does not get eliminated, like a student loan, you can put that in a Chapter 13 and pay 10 cents on the dollar if your budget allows for that. However, at the end of 5 years,
you're still going to have to pay for that student loan.
You're going to owe the other 90% plus interest. But what did you do during that 5 years? You gave yourself some breathing room. You lowered your payment effectively so that you can maybe afford housing, transportation, things for little Johnny. You've changed your financial situation for the better by utilizing the federal laws under Chapter 13.
But absent a student loan, I mean, what happens with those other debts? I mean, do you have to pay the late penalties and interest in terms of paying off that debt?
Technically, yes, if it's non-dischargeable and you don't pay it in full.
If it is in terms of a Chapter 13, you're still going to have to pay your the late fees and everything else?
Well, only if it's the situation you were talking about where it's a 13 after a 7. But typically in a regular Chapter 13, the late fee stop, the interest stops, and you pay less than 100% back. In most cases, it averages around 25 to 40% on average for payback of unsecured creditors, which are medical bills, personal loans, utility bills, things of that nature, items that are not secured by any kind of property.
And you know what you see a lot of times too, the people come in and they're trying to get a loan modification, and here's the kicker, is that they've contacted their lender and they're trying to get that loan modification because they're not behind yet. And you know what they get told? They get told, oh, we can't help you until you're what? 3 months behind.
Right. Well, good conduct in terms of paying mortgages does not get rewarded. So you're in no good situation if you're making your mortgage payment expecting a modification. But on the other hand, if you're making your payments, you don't need a modification. A modification is for someone who cannot afford to pay and needs a change. But where I thought you were going with this is that
It's your arrearage that you owe.
if you do a bankruptcy under Chapter 7 and eliminate your debt, you have a greater likelihood of getting a modification because your lender knows that you've eliminated all that other debt and now you can make the mortgage payment. So a lot of times people actually file the bankruptcy and then apply for a loan modification and get it.
But that's no guarantee, though.
There's never a guarantee, Jesse.
Right. Never in anything, correct? Let me ask you this. There are a lot of similar questions that people ask that are applicable to either Chapter 7 or Chapter 13. And, what's the turnaround time for a Chapter 7, a fresh start? From the time I come into your office and I hire you, Dave, and now I'm going to meet you on Monday, and you've got the petition, I'm going to sign it.
I'll tell you what, if we rush everything and you have everything ready to go, you could be filed within a few days and your debt can be eliminated effectively almost immediately, but the case does last for about 90 to 110 days, just to give enough time to appear before a trustee and to give creditors an opportunity to object in case that you've done something fraudulent with regard to a certain debt. For example, you might have run up a credit card or you might have taken a loan out on false pretenses. Those creditors have an opportunity to object and hold those debts still due and owing after a bankruptcy. So you definitely want to talk to a professional and make sure that if you've done anything recently, you wait to file.
Okay, and then at Chapter 13, which is consolidation partial repayment, and we talked about that a little bit, which could be anywhere from
Well, you're looking at
36 months, 3 years to 5 years, right?
Right. If your income, household income, is under the state median, then you qualify for a 3-year payment plan. If you're over the median, it's a maximum of 5 years. It has to go the 5 years. However, in certain cases, if you're paying back 100%, you can pay it back quicker and get out of bankruptcy quicker. On the other hand, if you're paying 10% back, you want to take advantage of the time because if you can pay it off quicker, the trustee might jump in and say, well, you can pay more than 10%. So again, you need to consult with an attorney. There's a lot of nuances in bankruptcy. There's a lot of little deadlines that you have to make. This is definitely not something that you'd want to go to someone who files a bankruptcy every once in a while. You want to go to someone who only does bankruptcy every day exclusively to get your best advice.
Well, that's a good intro for the next question that we get asked a lot, and I'm sure you do too, and that is, can I go to the office supply store and use those forms that they have, or forms that maybe I found online, and just do it myself? Why do I need to pay you anything?
You can do it yourself. You could operate on yourself. You can cook your own food. You can build your own house. The question is, are you capable? Do you really want to learn the process and go through that situation? Back in the day, before the law changed, October 17, 2005, before that law changed, people could go to office supply, pick up the forms, fill them out, even handwrite them, pay the filing fee, and maybe get through the case. Maybe. Today, very difficult.
Because the rules have changed.
The rules have changed, the forms have changed.
And you need to know what you're doing. You need to have that knowledge.
Yeah, there's all kinds of requirements now in terms of what you need to provide. 2 months of paycheck stubs or other proof of income. 1 year of a federal tax return. You must submit to a credit counseling session before you file the case. And that credit counseling must be done through an accredited counseling.
So if I don't know any better and I go ahead and I file it and I haven't done that, and then I find out and then I go ahead and do it, the counseling, what happens?
You just wasted $306.
Oh,
you just wasted your filing
I'm going to have to file it again?
You're going to have to file it again unless you convince the court to give you a pass, but that involves bringing a motion before the court.
So things that generally the general public doesn't know how to do. I mean, you could certainly represent yourself, but it's that complicated.
Right. The days of filing bankruptcy on your own have passed. Most bankruptcy attorneys will work a payment plan. They'll make it affordable. Once you know you're filing, you're not going to be making any minimum credit card payments. So you're going to have available money, and a good attorney will work a budget for you after you file so that you don't fall into debt again. That's what a good attorney will do, help you stay out of debt. Okay?
Well, let me ask you this. Again, you know, people ask all kinds of questions when they're going through the bankruptcy. And again, it's just they're scared, they're worried about what's going to happen and everything else. What happens if my situation changes during the course of a bankruptcy? What happens if, for example, we filed it, let's take Chapter 7, fresh start. Okay, so, you know, we filed this, Dave, and after we file it, something happens to me and I rack up a huge amount of medical bills.
Okay, after the filing, you incur
After
medical
the
bills?
filing.
Okay, well, you're in a situation where you cannot put that on a bankruptcy. Here's the key with a bankruptcy: the date of filing in a Chapter 7. So if you file on a Monday, and then on that Tuesday, you're hospitalized and you have a $10,000 hospital bill, we cannot put that bill on your bankruptcy because it's post-petition. It's after the case was filed.
Can you dismiss it?
You
And
can't
file it?
Well, technically you could, but again, you're going to pay another filing fee, and you're going to have to appear in front of a trustee. But
Who may or may not object to the discharge.
You technically could
Yep.
dismiss the case. What they really want to prevent is you dismissing the case to prevent the administration of an asset. So in other words, you file the case mistakenly believing you'd be able to keep your paid-off vehicle, and then you want to bring a motion to dismiss so the trustee can't touch it, and then liquidate the vehicle. If they get wind of that, that would be something that the trustee would object to. But something like a medical bill where you need to file again, the courts are sympathetic to that.
Okay. Well, let's take it now for Chapter 13, which is consolidation or partial repayment. Let's say now we have the planned payment, and let's just say again 5 years I'm locked in here, and my available income, a monthly income after the allowable expenses is $500, and that's the planned payment. Now let's say that something changes and I'm making less money.
Well, if you're making less money, there's a chance we can come in on a motion to decrease the planned payment. However, you have to keep in mind, creditors have to be paid a certain amount under the plan, especially secured creditors, houses, cars, other secured items. And it might be a situation where we can reduce the planned payment, or you might be running the maximum already and we can't reduce it. So it's a case-by-case basis.
So what happens if we're in the middle of the Chapter 13 and I lose my job?
Well, you got a couple options. You can let the case dismiss. You can look to convert to a Chapter 7 if you haven't done so.
You can convert. So now the reason I couldn't file a Chapter 7 before was because I made too much.
Right. Well, there's asset considerations too. If you have a lot of equity in your house or a paid-off vehicle, you're not going to be able to do a Chapter 7 or convert to a Chapter 7. However, if the only reason why you were doing a 13 wasn't because of assets, but it was because of budget, you had available money, and now you don't, Chapter 7 would be allowable, and probably a good idea if you have a lot of unsecured debt.
Well, a lot of questions that people ask too, because they, and actually, I just want everybody to know too, you should ask questions. Not only we talk, the same is true. You do your research, you talk to the attorney, and you ask these questions. This is your life. I get so many people who come in, they don't even know how much they make, Dave.
Right.
I mean, you should at least know how much you make.
Right. The internet has changed everything. 15, 20 years ago, if you wanted to file bankruptcy or do any kind of legal matter, you can maybe go to the library and look up some information. Now you have everything online. There's no excuse for not looking on an attorney's website, seeing what information is provided, seeing whether they've written on the subject, do they have any videos on the subject, do they have any referrals, and then go make the visit. Go into the office, see what the office is like. Is it a sharp office? Is it clean? Do the people know what they're doing? Or do you get the impression that they don't really care about you, they're not really set up to do bankruptcy, the staff isn't helpful, the attorney couldn't answer your questions? This is all stuff you can find out with little research online and a quick 20 or 30-minute visit to an office. See if you have a comfort level with that attorney. Most likely, if that attorney is qualified, you're going to find that you feel comfortable.
So, because it's important to have a good fit with the attorney that's going to be representing you, correct too? So if I don't like you, Dave, or there's just a conflict, then
yeah, you want to have a good fit. It's not the same as other types of law where a divorce case can last a year or two.
Right.
I mean, you're going to have kind of a shorter period of time with the Chapter 7, but importantly, you want to make sure that the attorney is aware of your situation, can answer all of your questions.
Will you take calls for me? 5 days a week?
I take calls from clients.
Not all the
I take
time. What I'm saying
emails.
is, if I have questions for you, we had our consultation. I'm still thinking about it, and I got a question that I forgot to ask you.
Yeah, I'll certainly do that. And we provide reading material on the topic. We have books on the subject that people can take home. I've got a book that I tell people to read it over a weekend or over an evening. It's a 20 to 25 minute read. That's everything they need to know about Chapter 7 and nothing more. Okay, because you can read for days on the subject, but most of it doesn't apply to you. People want to know, what are they going to ask me? How long does it take? Do I have to go to court? What do I have to produce?
So you're giving them, in the nutshell, the kind of the basic outline of what they need to know.
Right. I want them to feel comfortable with the process, because what I found over the years is if you have an educated client who's aware of everything and is comfortable with the process, they're going to have a better experience. And that's a better reflection on me, the attorney. So I want my clients to know what's going on. This isn't like a surgery where I knock them out and do the procedure. I want them to know every step of the way what's going to happen so that they're aware.
And that's informed consent. That's important. Speaking of which, a lot of people want to know if I can keep my car. Hey, listen, you know what, Dave? And I know you've said that I could have a new car. I could get a loan for a new car after my bankruptcy. But I kind of like this one. But I'm afraid if I do the bankruptcy that I'm going to lose it.
No, you can keep your car. If you're doing a Chapter 7 fresh start,
right,
and you have an auto loan,
and I'm up to date,
and you're up to date, and there's not significant equity, so you owe approximately what it's worth, you can reaffirm that debt, which is agreeing to sign a contract saying, I want to keep it, I'm going to continue to pay the same monthly amount, and I'm going to keep that car. It's going to survive through the bankruptcy. And then Chapter 13, of course, they do keep the car.
And you did pay the whole thing.
Because they're repaying it over time. Through the Chapter 13 trustee.
In the Chapter 7, I could have at least $2,500 in equity, and maybe a little bit more in that vehicle.
Yeah, you can have equity in a vehicle. You can have a certain amount of money in a bank. You can have all your necessary clothing, some household items.
Well, let me ask, what about my pension? My goodness, you know what? Here, I've been working all this time, Dave, and now I'm in the a little twilight of my years here, and does that mean I'm going to lose my pension to my creditors?
No, ERISA qualified pension, profit sharing, 401k, and other retirement accounts are protected. They're exempt, and what that means is you can eliminate your debt under Chapter 7, and whatever you have in those accounts is protected. One of the mistakes that I see from clients is they'll come in and see me, and they've already exhausted, taken out from their 401k.
To pay their creditors.
To pay creditors, and where are they now? They're back in that same situation where they didn't pay off all the debt, the interest has accumulated, and now they've lost all their pension.
And now they don't have anything left.
Right, so the thing to do is when you're struggling financially, get in and talk with someone early, because you want someone to give you advice so you don't make mistakes. You don't run up the credit cards. You don't transfer a paid off car out of your name to your brother. You don't do things that are going to cause a problem in a bankruptcy case.
And those are all questions that people generally ask and they want to know. In fact, what's the threshold with respect to, hey, listen, you know what, can I keep my cards, Dave? You know what, I'm going to need a card after I do the bankruptcy because I'm just going to need it to buy stuff with. But I'll pay it off. It's got a zero balance on it right now. Well, maybe $10 because I paid it, but I use it and pay this particular card out of all of them. Can I keep that card?
No matter which form of bankruptcy you're filing, you're not going to be able to keep credit cards. Plan on losing those credit cards. You'll be able to get another credit card after your case is filed, a secured credit card where you put money in the bank. There is life after bankruptcy. There is an opportunity to get credit. You just have to be patient, follow the process. Don't try and jump ahead. Don't try and get credit before you've gotten out of debt. Follow the steps. You will get credit again. People have to understand there is life after bankruptcy, and usually a pretty good life because you've eliminated the debt, you've eliminated the stress from your life, and most likely you become a better spouse, a better worker, a better member of the church, a better everything.
Yeah. And it's just nice to get that off of your back. I've had a couple of consultations where you have individuals that come in, they're on Social Security, that's all their income. Is Social Security protected?
It is protected. That's all we have time for, Jesse. Thanks for joining me.
All right, Dave.
We'll see you next time on Legal Action. Take care.